Hey guys, and today we're going to talk about the effect of evidence being ruled inadmissible on jury decision making. Now, this study is obviously for the OCR A-level psychology specification, and it's for the forensics option of the options in applied psychology paper. Now, I want to say for the start of, as I was doing these videos, there will be more tech videos coming, and because I know some of you guys aren't really that interested in these psychology videos, so there are definitely more tech videos coming in the near future. But for right now, we're going to talk about the effect of evidence being ruled inadmissible in a court case. Now, the study you need for this on the specification is Pickle 1995, and so let's just go over a bit of background first. What is inadmissible evidence? Well, inadmissible evidence is evidence that has been ruled usually by a judge as evidence introduced by one of the barristers, that's either for the prosecution or the defence, that the judge has ruled as unlawful, and they've ruled shouldn't have a bearing on the jury's verdict. This study is really about finding out whether inadmissible evidence does have bearing on the jury's verdict, and about what can be done to make them respect the fact that it is indeed inadmissible, and it shouldn't affect their shouldn't affect their determination. So let's also talk about what type of evidence can be ruled inadmissible. Hearsay evidence is a classic. Reporting what somebody else has said to you in a court case, that is unlawful, and that is inadmissible evidence. So too is evidence of prior convictions and character evidence, unless it is directly related to something that's going on in the case. You also can't bring up cases where the accused is alleged to have committed an offence, but that was never proven. They were never tried for it. They were never found guilty. You can't bring up evidence like that. So with all that out of the way, let's talk about this study. This study had three main aims: to investigate the effect of prior convictions. So again, that's a form of inadmissible evidence on a jury's decision of a verdict of guilty or not guilty. Aim two was to investigate the effect of the jury giving instructions or not giving instructions on the jury's verdict. So are they more or less likely to respect the fact that the evidence is inadmissible if you give a legal investigation, if you give a legal explanation, or if you just leave it alone? And three was to assess how much the credibility of the critical witness who had alluded to the inadmissible evidence affected the response by the mock jury. The participants were 236 students from Beatty University. That's B-A-T-I. I don't know whether that's Beatty or Batty, but from that university, 236 students, most of which were contributing partially as part of a course requirement. So you might have some demand characteristics there if you know that you're participating as part of causal calamity, you might be more likely to do what the experimenter wants. Also, psychology students and just students in general may not be representative of anyone who could be called for a jury, because they might be more used to taking in large quantities of information. They might be a point in their lives where they're more or less impulsive and more likely to disregard what people say to them. So there's some sampling bias issues there, but actually it was an independent measures design with every participant being assigned to one condition. So there was a condition where the evidence was ruled inadmissible even after the defence barrister gave an objection. Then there was two inadmissible conditions. One where the judge ruled the evidence as inadmissible and then just moved on, didn't give a legal explanation, and one where he did. The other one was a control condition where the evidence wasn't introduced, and as such those participants weren't asked to complete one of the measures about how much the inadmissible evidence had contributed to their verdict. So I'm not sure if I've been through this already or not, but there was the stimulus trial was an audio tape of approximately 35 minutes in length, which was a fictitious trial, but it followed the thing of normal trial. So you may have some ecological validity issues there. You may not. You can decide. So let's talk about the measures the participants were asked for after listening to the case. They were asked for whether they believe the accused to be guilty or not guilty. So that's a straightforward closed question type measure. The extent to which the evidence had, the inadmissible evidence had led to their verdict. So that was on a 10-point Likert scale question, and there's some social desirability there, because if you've been told to regard some evidence as inadmissible, you may not want to admit that you didn't do as you were told and didn't regard it admissible. But that was really the critical measure. There are standard 10-point scale how much the inadmissible evidence had contributed to their verdict, and then they were asked on a 7-point scale to rate the credibility of each witness, and there was subconditions within each of the admissibility conditions about the credibility of witnesses and how that influenced. After they'd given those measures and after they listened to the trial, they were debriefed and thanked and dismissed. So that was the procedure. Let's talk now about the results. I've got some notes of it to look at. where the evidence was of their prior conviction was ruled admissible, unsurprisingly that gave the highest percentage of convictions, and it also made participants the most confident the most confident in their decision, the highest probability of guilt. This is where it gets really interesting. Where the evidence was presented inadmissible, but with an explanation, the percentage of guilty verdicts was 55%, whereas without an explanation, it was only 43. So we'll come to conclusions in a minute, but 43, 55, more, 12% more participants gave a guilty verdict when the judge gave an explanation of why the evidence was admissible than when he just left it alone, ruled as inadmissible, and moved on. So that is quite a big difference. If we look at the confidence between the two conditions, participants were more confident in their guilty verdict. Remember, 55 versus 43%. They were more confident in their guilty verdict when they'd had an explanation. 0.6% over 0.6 on the rating scale over 0.55. So having an explanation makes you more confident in your decision, but yet you're more likely to disregard the explanation and give a guilty verdict. So that's pretty interesting. The control group, which I the difference in control group was they weren't asked for the measure of how much the evidence had affected them or not. They were not given that question. The control group had a 42% rate of guilty verdicts, but the real big difference here is that the two inadmissible conditions, 43 and 55. So if you're given an explanation, you're more likely to disregard the explanation than if you're just told something and you're not given an explanation. Let's I'm just reading here. They found that the credibility of witnesses, which you remember was the third measure, the third aim, the third thing they wanted to look at. They said here the critical evidence had no bearing on the rating of the person's honesty. The person was actually a co-worker of a co-worker of the person being tried, and the crime was against the supervisor. So the co-worker's credibility and those different conditions had whether they ruled as inadmissible or not, that had no bearing on the co-worker's credibility. So the conclusion obviously is that if you want people to honour being asked not to consider evidence in a case, just to tell them not to and not give an explanation as to why, which is pretty interesting, really. Okay, so let's discuss some evaluation points with this. One is ecological validity. It wasn't even a real trial. It was a made up case with a made up situation. But they made a point of saying that when they made the stimulus material, they made it follow the normal trial procedure. Started with the judge's indictment, ended with the judge's instructions, and sort of followed the main trial procedure. Another thing to note is that it was a mock jury, so because they're only being because they're in an experimental situation, they might not think as hard about it as they would if it was a real person's liberty at stake. Also, linking to that, there's demand characteristics issues with the fact that it was a course requirement, so they think that they might do worse on the course if they fail to follow what the experimenter wants from them, so that might have skewed some of their answers. And also, you've got it's a self-report, so I don't normally say this specifically in relation to self-report, but in this case, the self-report measures might be reductionist because the data was just quantitative. They weren't asked they weren't given the opportunity to answer any other questions about why they've done what they've done. They were just given rating scales, and so sometimes on rating scales it's a bit difficult to place where you are. If you got one to 7, and they're asking how credible is this person, you might have real difficulty placing it on one of those areas. So those are just some evaluation issues to keep in mind. You've also got the usual issues that seem to be becoming a feature of these studies, independent measures, so participant variables, low reliability. It might not have just been the independent variables that affect the dependent variable. It might have been the participants' general outlook on that day. That they might have decided before they'd even gone in and heard the case what their answer was going to be, and that's another issue with it being not a real person's liberty at stake. And having said that, though, on a positive note, there was no ethical breakdowns here. They were all introduced and told what they needed to do, and they were all debriefed and thanked afterwards. However, I've just thought of this. You could say there's an ethical issue with regard to informed consent, because if they're doing it as part of a course requirement, they might feel like they have no option but to do it. So they just give their consent anyway, even though they don't really want to. They just feel like they have no choice. Anyway, guys, Pickle 1995, effective evidence being ruled inadmissible. Hope you've enjoyed this video, guys. Thanks for watching. Check out my website address, it's down below, tom-rogers.com. Thanks for watching this video, guys, and I'll see you in the next one. Bye bye.